Good evening, ladies and gentlemen. Welcome to our training session for July. My name is Leigh Maingard from Intersect. Thank you for joining us this evening. I'd like to introduce also, just our two guests, Nicola from ZDFin. Hi, Nicola. Thank you for joining us. And then also Zerlinda from Merwe from TVDM. The topic tonight is how to deal with arrear levies and then also improvements to common property. So we have 60 minutes. Just from an operational perspective, everybody is on mute. If you do have a question, you're more than welcome to put it in the chat box. When we get to the end of the session, we've got some time left. We can look at some questions in the chat box. Okay, so this evening we're going to look at some dealing with the arrear levies and improvements on common property. We have in the past done some training sessions on arrear levies and how to manage that. We're gonna have a look, do a different kind of approach this evening. We've got Nicola from ZDFin. ZDFin does quite a lot of levy financing and financing for schemes for external projects. So we're going to use her in dealing with some of the aspects of more on the legal side to give us some more insight on how those things work. And then on improvements on common property, again, we have looked at common property on various aspects, exclusive use areas, and then also specific maintenance. So we're going to have a look at the improvements on common property and more specifically essential and non-essential improvements to common property. And they will get Zerlinda to join us and answer some questions on that. Okay, so in every aspect of sectional title, there's always some legislation that needs to be adhered to. And predominantly in this case, we're going to look at, I'm not going to refer to any specific parts of the Sectional Title Schemes Management Act, but the Sectional Title Schemes Management Act and also the Community Schemes Ombud Service would be relevant acts or legislation that you would need to look at or can refer to in terms of requirements in dealing with arrear levies and then also improvements to common property and maintenance to common property. So we're first going to deal with the arrear levy scenario. So the first part we're going to look at is levies and the obligation to pay. Sorry, before we start, I just want to check, Nicola, are you muted? Can you unmute yourself? You can just maybe just say hi so that I can hear that you're there. Nicola? Let me just, I think I need to allow mic. Okay. Are you on mute now?
No. Hi.
Okay, there you are. Good. Sorry, before I start asking questions and I don't know where you are, thank you very much.
No worries.
All right.
Thanks for having us. I've also got Junaid with me here as well. He's one
Junaid.
of our new young attorneys who have joined us. So when it comes to court practices and things like that, we prefer to have young blood in so they can teach us all the new tricks in court. So Junaid's also here if we need to go through anything.
Welcome, Junaid.
Thank you.
And we can share my mic anyway, but so at least you can see his face there next to us.
Perfect.
Is there anything that you'd like me to discuss, or are you going to go through it, Leigh, and then?
No, so I'll start here and then I'll start asking some questions from there. Cool. So I just wanted to make sure that you guys can that I can hear you guys. Okay, so in terms of levies, obviously arrear levies, they derive from the fact that there are levies payable. You can see from the slides really the obligation to pay. So the obligation for an owner in a scheme to pay levies. But we first look at how does that come to that point. So the body corporate has a responsibility, and the responsibility of the body corporate is to establish and maintain administrative and reserve budgets. So we all know that the administrative budget is your annual budget where you prepare and plan for maintenance that you're going to incur during the year. Maybe some planned some planned expenses or maintenance, but not necessarily of a capital nature, because we know that we then talk about the maintenance reserve. And then your reserve budget, which obviously is the other budget that you need to prepare more on the maintenance side. So the annual operation costs and future maintenance repair of common property is effectively what I've just said now. So your operational costs, your annual, that will be in your administrative budget, and then your future maintenance repair of common property will be in your reserve budgets. So from those budgets, what will happen is that there will be a levy calculation, and then which the trustees are obviously responsible for to determine. So when the trustees prepare the budget, they need to take cognizance of what maintenance needs to be done on a monthly, quarterly, biannual, and then also on an annual basis. So that will give them the opportunity to then determine what the contributions have to be to the budget. And those contributions are effectively then, we talk about contributions, but for all intents and purposes, contributions are the levies that are payable by the owners. And then those levies become due and payable when the trustees have passed a trustee resolution to that effect. And we'll have a look at that in a little bit more depth on one of the other slides. And then I think what is quite important is that the body corporate, and we also see when we talk about how the body corporate proceeds to collect levies, is that within 14 days after the AGM, the owners of that scheme needs to be notified in writing that they have the obligation to pay levies. It must be specified when the levies are due and payable. Nicola, just a question from my side in this regard. Specify the due date when levies are payable, but legislation says that the levies are payable on the first day of the month. Am I incorrect when I'm saying that?
No,
is this like
levies
a
are due
contradiction?
and payable on the first day of the month. Unless your scheme's obviously resolved that they're going to do the levies once off.
Right.
But otherwise they're due on the first of the month, and interest should run from the first, but it's become a industry practice that we give until the 7th of the month to let them pay. But by all means, it's definitely not how it should be. Legally, they should be paying by the 1st.
Correct. Okay. Have you ever come across a scheme where the levies are actually payable in advance for the year?
Yes, I have. Yeah.
Oh, really? Okay, that's quite interesting. And then owners, I mean, the levy is quite high just from an interest perspective, because I've never seen that in any scheme that I've been involved in. Is it not really high?
It's just a mixed breed of, you can either get your low levy amounts, or you've got your higher ones. It just depends on what the scheme wants to do. Then obviously some schemes you're going to have a decision at your AGM where if they pay in advance, or then they get a certain discount, which becomes an accounting nightmare for the managing agent, as you would know. But that's the discretion of the board and the members to make at the AGM.
Correct. That 10% discount if an owner pays in advance is quite an interesting one. Do you see that? I mean, again,
we do see it, but it's tricky for the building, because as much as you are giving that 10% deduction on the levy, you don't give the 10% deduction of the overall cost of the budget. So there's going to be a shortfall eventually. But I understand the incentive behind it. But yes, you do see it.
But I mean, from an operational perspective, you're giving somebody a 10% discount. You effectively need to budget for the shortfall, surely.
Correct, But the schemes don't budget for the shortfall. That's the problem.
No, 100%. I would imagine that they don't. It's almost, it's not the same, but it's almost, the discussion about, putting interest as part of your income stream, and using that interest portion as part of the calculation, which effectively reduces the levy part to cover your expenses. I mean, there's always a debate about, is it right or is it wrong?
I think it's hard to budget on interest when there's no guarantee the money is actually going to come in. Isn't there also a tax liability on the income that comes from interest? Then you have to pay over to SARS.
All right. We're digressing. So just going back to the due date. So anyway, the legislation says that you must specify the due date, but legislation also says that levies are due and payable on the 1st of the month. You did mention that that bodies corporates, there's like let's call it untold rule or kind of understanding that people have
Industry
a
practice.
correct, of 7 day. And quite interesting, I had a long debate with a chairman or trustee recently about that. Because the management system that we use charges the interest in arrears. So at the beginning of next month, it will calculate the interest for the previous month, and obviously that will be based on when the person actually paid their levies, how much money was outstanding after they'd paid that. So it becomes quite a calculation to do. So the management systems are set up for that. I know that certain other systems you can actually set it that there's an interest-free period, let's say for 7 days. So once the receipting's been done on the 8th and you haven't paid, then interest will only start calculating. But yeah, I understand that. Then that letter also needs to state the interest rate payable on overdue contributions and charges. And it also needs to include the details of the dispute resolution process if an owner wants to dispute the contribution and charges that they are being charged on their levy statement. So those are requirements in terms of legislation that needs to happen 14 days after the AGM, and we'll see why when we get to some of the other slides. All right, so the collection of outstanding levies. So obviously you go through a process, the body corporate decides what period of time an owner will be given before they let's say hand it over for the lack of another word. In your experience, Nicola, do you find that that grace periods, I mean, there's owners always ask for how much time must we give owners to pay their levies? I mean, it's such a weird kind of thing to do when legislation says your levies due on the 1st of every month. I mean, how do you, is there another way of dealing with it? I mean, is there any reason why people should be given a month, 2 months, even sometimes 3 months for them to pay their levies?
So no, you should have your inside credit controllers doing their credit control. If your company's set at doing giving until the 7th to pay, if any monies aren't paid in the account by the 7th, then your credit control should be starting on the 8th with an SMS or a letter or something like that to get the ball rolling. I'm not a fan of handing over for small amounts. We see it. We do the executive managing agent side as well, where we work with the managing agent, and we, as trustees, we take over the collection of the levy function. And with that, coupled with the levy finance portfolio that we have, we often see accounts that are handed over at 3 months in terms of the handover resolution for small amounts. And unfortunately, there are some unscrupulous attorneys out there, and it's like an open checkbook to them. So you find accounts where you've handed over for 3,000 Rand or 2,500 Rand, but there's a 6,000 Rand that's actually been loaded onto those accounts for legal fees, and then it becomes a collection nightmare. So for me, I prefer to do soft collection internally, and then hand over to a soft collection firm externally. And those soft collection attorneys that we use on our panel, they only charge DCA fees. So at least then everything's recoverable from our side.
Just explain that DCA, sorry for interrupting, just explain for the attendees, the DCA fees.
So there's different tariffs that you can charge in terms of what we bill to owners. You've got in terms of the previous legislation, which was incredible, and I was very upset when they changed it. It said, the Sectional Titles Act previously said that owners were liable for all attorney-client legal fees, which meant basically anything that was raised we could recover, provided that our attorneys obviously weren't going overboard. Then they changed it with the recent legislation to say, or not recent, but current legislation to say that you could only raise or only charge or load onto the levy account taxed or agreed fees. Now, when we do unreasonable charges. So when we do soft collection on a DCA tariff, it's debt collection tariff. So for example, where a letter of demand would cost on the DCA tariff would probably be around 23 Rand, around about. and your attorney and own client, which is what the attorneys are going to charge you for the same letter of demand, is going to be about R1,000,
Oh, wow.
or whatever it is that they raise on their side. So
Yeah.
it all depends on the different type of tariff that you use. And with us in our levy collection, we can only get back party legal fees, which is why there's always an issue with rolling so many summonses or taking legal action too early, is that you end up with these high amounts of legal fees that you can't actually recover from the defaulting owner unless they consent to it or they're taxed. So you have to make sure that your attorney panel is working either at the DCA, doing your soft collections at DCA tariff, which is then makes them basically debt collectors, and those fees are recoverable, or when you hand over to an external panel that they charge the tariff that you're going to recover on those legal fees, so that you protect yourself from the shortfall. Because what you don't want is having the paying members ending up paying and covering the shortfall of the non-paying owners. And I get so frustrated when I see these things on Facebook about, you know, so-and-so hasn't paid his electricity, paid his levies, so they've disconnected his electricity and whatnot. And the reality is yes, it's unfair for that owner who isn't paying, but the whole scheme could end up having their water and lights cut by one person who hasn't paid. So I think you have to be very careful when you're handing over, that you use the right people, that you, I digressed on your question, but
no, it's fine. Yeah, look, I think it's quite interesting. I mean, earlier in the year, I did a session with Willie from ZDFin, and the whole electricity, cutting off electricity, and yes, you can do it, but you can only do it when you have a court order and those kind of things. So there are certain things that you can do, but you need to jump through hoops and follow process or change the rules or whatever. So there are many ways that you can deal with certain things, but there's a process to be followed. You can't just walk into the main meter room and just put the switch up and then expect the person. Correct. So
100%.
And also just quickly on the other thing was also the issue of legal fees being taxed, because that in itself, the taxing of those legal fees can take a long time. I mean, I've heard of a story of it's taken 2 years or 12 months to get to a point where the legal fees were taxed, and then you have you've got the problem where the body corporate doesn't budget for the unrecovered legal fees, and they keep on spending that money. So they're effectively using money from their reserves technically, because they haven't budgeted for that. And I think that's a very big problem. And I think generally speaking, and correct me if I'm wrong, but I think generally in the industry, it's a shortfall on the budgeting side that legal fees are not budgeted for, because you've got to make a provision for those fees, because the legal fees can be taxed and there's always going to be a shortfall.
Correct, And then the members are going to have to pay the shortfall.
Correct.
But you've got to hope that you have an attorney appointed that's within the tariff, so you can try and recover as much as you can. The other problem you have with the external panel of attorneys is they'll say that a judgment's been settled. So you handed over 8,000 Rand 3 years ago, the owner's been making 500 Rand payments every year, and all of a sudden that 8,000 Rand's been paid, and they say, oh, that matter's been settled. No, it hasn't, because you haven't taxed your legal fees and you haven't accounted for the interest. So you actually should be keeping a separate recon of those matters that were handed over, calculating the interest and making sure you recover the tax legal fees before those attorneys close their files. Because you don't want to have a situation where you end up writing or removing, when we hand over to external panel of attorneys, and you'll deal with it later on your slide, but giving them the correct information to actually hand over, and making sure your compliance is correct before you hand over to external panel of attorneys. And when you do that handover of that recon of the account, when you aren't taxing your legal fees and collecting the interest on that judgment amount, you end up with an account that's basically made up of interest and legal fees, and then you can't actually hand over. And if you do hand over the account with legal fees on it, then you end up with a query. So
it just kind of goes around in circles. And I think again that brings up the issue of where we're managing agents or trustees for that matter give instructions to the manager to just debit the owner's account with the legal fees, which would just down the line, it's going to create problems. If the owner doesn't pay it, or they dispute it, you're gonna end up in, you know, months and months of communication and unnecessary legal fees that actually line up the you know, the body corporate's exposure or liability.
So it depends on how the managing agent system works, and I've come from being within a managing agent. So
Yeah.
it all depends on the managing agent system. I mean, I also disagree in having two separate invoices running, one for legal fees and one for levies, because then which one do you pay? And one, you end up having the levies paid and then not the legal fees, whereas you want to try and get your owners to sign an acknowledgement of debt admitting to those legal fees before you hand over to formal summons. So at least you've tried to do your collection side in-house or with your soft collection panel. So I think it depends really on how the managing agent system works, but it's a tricky terrain where you aren't showing those legal fees, because also sometimes the owners, if it's an investment property, they might not know, you know, that their accountant who they have 167 units hasn't paid the levies this month, and when they receive that legal fee loaded onto their accounts, they very quickly question it. So it does. I hear the legislation and the case law says you can't raise it on the account unless it's taxed or agreed. But again, it depends on the managing agent system and how you want to work it. But ultimately, when you hand over to your external panel, you cannot hand over with legal fees on that recon. That must be extracted.
Yeah. Look, I think we can probably have quite a long discussion about that. But yeah, let's just move on from this point though. So the first, almost like your first, one of the first things is to send a final notice to the owner. And in that final notice, you've got to tell the owner that interest is payable in respect of the overdue contributions and charges at the date of that final notice. Then also that the amounts will accrue daily. The amounts that will accrue daily until payment is made. So in other words, what are the amounts that's outstanding and what the interest will be on that, and then that the body corporate intends taking action if not paid within 14 days. So that would be a standard kind of communication to the owners should they fail, you know, not to pay their levies or SMSs or phone calls or emails to them. So that's quite an important thing that will also assist with should you go further with legal action. The interest that gets charged, the interest is determined by the trustees, and it must be a written trustee resolution confirming what that interest is. And as long as that interest is not or exceeds the annual rate of interest in terms of the National Credit Act. Nicola, just on the annual interest rate, because you know it's always a kind of a contentious thing. Well, not necessarily contentious, but I mean, what is the maximum annual interest rates in terms of the Credit Act?
So the maximum is the Incidental Credit Act, the Incidental Credit rate, which is 24%, which is 2% a month.
Correct.
But there's case law that says that the National Credit Act does not apply to levies. So we always say don't go higher than the incidental credit rate, which is 24%. And I know a lot of body corporates want to make it as punitive as possible, but there's also the income side of it, which becomes a tax issue, and you don't want to end up with a query where your magistrate's saying that it's unreasonable, the amount that you're raising. So provided it's agreed at your AGM by your members, you can raise it, but I wouldn't go above the 24%.
The 24%,
yeah.
Okay. So I think a lot of schemes also look at charging the annual rates of prime plus 2%, which is what, about 13.75% for the year, which is obviously, you know, a lot less than 2% per year.
Yeah.
Okay. All right. So we're talking about legal costs. So Nicola's kind of touched on that already. Obviously the member is liable for any reasonable costs and disbursements. I think the important kind of words there, or the word is the reasonable costs. And then what we've already mentioned, or Nicola's mentioned, is it must be taxed. All the member must agree to it. So in this case, The reference that Nicola made is that the managing agent and its debt collecting department deals with acknowledgement of debt. So once the owner has signed acknowledgement of debt, they confirm that they're due and payable the arrears, and they agree to the legal fees, and that's the way that the body corporate can then debit the owner's account. Nicola, just from an interest perspective, I mean, do you find that owners, there's a lot of pushback from owners to actually sign those acknowledgement of debts?
No, I don't have pushback from owners to sign AODs. I mean, we're either going to proceed with legal action or they sign the AOD.
Right.
If you have an owner who's genuinely wanting to settle a matter, then and they're acting in good faith, why would they not sign it? They're
Yeah.
agreeing to pay on a specific day to settle their debt. And then
Mm,
if they say that they're not prepared to sign it, then it's kind of a red flag that they're not
yeah.
going to stick to it.
Yeah.
But it is a good document to have, because once they've acknowledged it and they've agreed to those fees, you can then just proceed a lot quicker with getting your judgment against that
Yeah.
unit.
Correct. Okay, but I think more specifically on the legal fee side. So yes, you
Yes, most
obviously
certainly. Yes,
internally, but you've got, I mean, you're acting as a debt collector, so you're entitled to recover those costs from the owners anyway, the
correct. Yeah.
letters and the SMSs and this kind of thing. Okay,
Yes,
so this is
all your general debt collection fees
yeah,
are reasonable charges that you will
right.
recover.
Yeah.
So
Was
your
also
late
legislated.
penalties, DCA fees,
Yeah.
all those kind of things, those are easy to recover.
Yeah,
And provided you're a registered debt collector, you
correct.
can raise them,
Yeah.
and they're are due and payable by the owner. So I see there's a message here. What about penalties for late payment? Yes, they are raised on the levy account, and the owner's liable for them. When we go to court on those DCA fees that are raised for your late penalties, we get them back very easily. We don't have an issue with them.
Yeah. Yeah, I think and also, I mean, just I'll ask you the question, but at this stage in the collection process, you haven't actually gone to an outside attorney or one of those ones. So the legal fees are not exponentially increased. You're dealing with, like you said, reasonable costs that the owner is going to pay because of the current situation he finds them in. So if he's paying on time, and in terms of the acknowledgement of debt, he's not going to get an SMS, he's not going to get an email, and he's not going to be charged for those fees. So
Yeah,
I think it's a pretty simple process up till that
correct.
point.
Yeah.
Yeah. All right. So then the other one was so withholding of disputed amounts. So obviously what we see is owners sometimes levies are charged, or I guess what we see more often is where electricity or water is recovered from an owner, and the owner disputes that and they don't want to pay their bill for the month. Now, legislation clearly says that it's not allowed, even if it's disputed. But there is legislation does allow an owner to dispute that, and they've got to lodge a dispute with CSOS, and in that application, they ask that the contribution is incorrectly determined or unreasonable. So obviously they leave that to CSOS to determine, and the body corporate or the managing agent will need to provide all the documentation, for that mediation to take place, and then hopefully there's no adjudication, because then you're effectively leaving it to the CSOS adjudicator to make a decision. But if everything's done correctly, then there shouldn't be a problem with that. But I think the point here is that even if you dispute, you can't not pay your levies. And if you do dispute, the best way to follow is to lodge a dispute with CSOS for for them to try and determine if the contribution is incorrect.
Yeah, correct. So
All
we
right.
often have that as well, just like where you've got a unit that's been damaged by water, when the
Yes,
owner will say
happens a lot.
they're
Yeah.
not paying it, they're not paying their levies because the body corporate should have paid for it, and you can't withhold levies
Yeah.
for
Yeah.
any reason whatsoever.
Yeah. Yeah. I think if we had a whole bunch of managing agents, I think that would be a very common occurrence.
Mm.
All right. So continuing on the collection of outstanding levies, CSOS collection procedure. We kind of just touched on that application to the ombud by the scheme. So obviously this is where the body corporate goes to CSOS, and the application is then for CSOS to rule that the owner is due and liable to pay their levies. And I made a mental note about this, Nicola. I mean, have you found yourself at CSOS where CSOS has ruled in favor of the owner? And obviously, the assumption here is that all your documentation is correct, all the notices were sent out, the resolutions are in place, everything like that. So I'm more looking at have you found that that the ombuds or CSOS has ruled not in favor of the body corporate, although they've done anything correctly?
So Junaid would probably be best to comment, but from what we've seen, I mean, it's.
I mean, if you make out a good case as to obviously you provide all of the supporting documentation and the arrear levies are due and payable, I don't see why CSOS wouldn't grant you your order.
Yeah.
And I don't think we've had an instance where our order wasn't provided, given a good argument.
Yeah. So I think, I mean, but when it comes to CSOS, it really is hit and miss. So initially, we all had such high hopes for CSOS. We really did. And we were like, this will really alleviate court time and get our matters done a lot quicker. I mean, when I was in practice, we used to stick our summons through and it would pop out the other side with a number on, or we'd go and stand in the default judgment line and get it stamped and we'd walk back out again. Now we're talking about 6 to 9 month delays for default judgment. So it's really, we were hoping that the CSOS would be able to really make that process a lot smoother and a lot quicker. Junaid's had quite positive feedback from CSOS. I've seen a very mixed bag. So depending on who your adjudicator is, it's really, and the region, I mean, that it's all so different. If you can have a good ruling, or you can submit 10 applications and get 7 judgments back straight away, and then you can be following up with 3 of them for 9 months. It really is hit and miss. I don't know.
But I mean, at the end of the day,
matter.
Yeah, that's why I set the scenario saying that, assuming the body corporate is, 100% on point, all the notifications, the calculation.
That's the problem, is you never know with CSOS. Like, you really can have everything in order, and then you get someone who has absolutely no idea what they're doing, and they make the ruling. So it really is hit and miss with CSOS, unfortunately. I wish it was more positive. We do sometimes, often refer matters to CSOS, but it's you never know what you're going to get.
Yeah. Okay. All right. Well, let's move on to the collection procedure in court. Personally, I've never been to court in terms of a levy collection scenario. I guess, Nicola, you guys probably have. But in this case, the body corporate is not necessarily going to CSOS. You're going to the court, and then you've got to comply with the Magistrates Court Act 32 of 1944. And while you're doing that application, you're doing an application for attachment and sale and execution of movable property. So not immovable, but movable property. And the result is that if an owner or person that's not been taken to court by the body corporate to pay their levies, if they don't have sufficient cover, in terms of their movable property to cover the debt, then the next step is to go into execution of sale of the immovable property. In other words, the sale of the apartment. And I think, Nicola, I'm sure you've got lots of stories about this, but I think in my experience, what happens is that unfortunately, you do get owners that habitually don't pay. They get pressurized, they pay a little bit, then the body corporate backs off, and then you go to court again, and the whole process just keeps on following through. And then it's almost like that old story where, you settle on the steps of the court, because the person knows that their property is about to be sold because they owe 100,000 Rand or 200,000 Rand in levies scenario. Hopefully you guys don't see yourselves there quite a lot, but I mean, that's a pretty simple, a regular kind of occurrence. Am I right?
Yeah.
And also the process, it takes such a long time to get to that point.
Takes such a long time.
Yeah.
It really does. I mean, that's where we were hoping with regard to CSOS, that CSOS we get the order quicker and then convert it to a High Court order and proceed then with attachment in the High Court. But
alas. Yeah, I think that's yeah, you're 100% right. I mean, that's why everybody was hoping for CISOs. Maybe they get better. I mean, there's certainly other aspects of CISOs that's definitely improved that we've seen.
Yeah, I mean, there was a great improvement here in Joburg, and then I think they just got overwhelmed again. So I think, they start doing well, and then
I think they probably just get
overloaded
overwhelmed
again,
because
and
I
then
mean, I think it's just because they're actually doing quite well and getting information from everybody. They need to process that. So then they get bogged down by that, and they kind of lose thing. But let's leave CISOs there for now. We can talk about that at another time. All right. So just going back to, well, not going back to, but taking the discussion further. So when the body corporate wants to claim, against an owner for contributions that they haven't paid, when you're making the application to Ombuds or the court, then there are certain requirements again, and these are crucial things that. And I mentioned that earlier, where I set the scenario where the body corporate has all these things in place, and they're the following thing: the signed trustee resolution confirming the contributions. We touched on that earlier. The notice to the owners confirming the contributions. The 14 days after the AGM letter that I've mentioned. Then the final demand sent to the owner to pay the rear levies. We've touched on that earlier. Then the copy of the owner levy statement. That goes without saying, because you've got to show where the owner started to go into arrears and how that arrears is built up of. And then the signed trustee resolution charging interest on overdue levies. So those are crucial documents that the body corporate must have every single time when you do proceed to legal or even go to CISOs. That information is going to be asked. It's absolutely essential that is prepared properly and done after each AGM. Yeah.
Yeah, correct. Yeah, and I think, like on our side from our panel, if they issue summons without having one of those documents and they end up with a query on their judgments, we won't pay the legal fees because they should have prepared their files correctly. Yeah. That's why they were handed over. Yeah, I mean, I can't. It can't be expressed enough how important it is that managing agents like yourselves, and I mean, I know that you do it, have the documents in place and everything's correct. And you hand over correctly, because I mean, we're sitting now with a 600 unit scheme where we're going through the files, and it's an absolute nightmare. Trying to reconcile levy accounts and figuring out what was going on with the attorneys. And often, like with our managing agents, we open our files as with a door number, but the attorneys sue with the door number, not the section number, and then it can be overturned data. So it's
served on the wrong domicile.
Because it's served on the wrong domicile.
Yeah.
Not both. The attorneys don't double check that when they take on the file, they don't do the deed search and check who is the actual owner of that unit. Is it a Mr. and a Mrs., or is it just one person, or is it a trust, or a trust plus someone? So they have to make sure they do that correctly. Otherwise, you end up all the way down the line with all your legal fees and
no results or no progress.
Yeah.
Okay. Moving on to the body corporate security for payment of arrears. I mean, in short, basically what we're talking about here is your clearance certificate. And just for those attendees, so the process here really is that the Register of Deeds needs to be satisfied that if an owner was in arrears or is in arrears at the time of selling the unit, that they've paid the outstanding levies to the body corporate, and then also if they've made an arrangement with the body corporate that it's sufficient to cover the arrears at the time of the sale of the apartment. And that's where the managing agent, because generally speaking, trustees don't really deal with this. That's where the body corporate, the managing agent, plays quite a big role, where they've got to prepare a levy clearance certificate that's then issued to show that the owner has actually paid. And then, I think for those trustees that are attending this evening, where they do authorize payments on WeConnect You, sometimes we get a lot of queries: why are we paying people back when the unit's been sold? And this is exactly the reason why. Is because we make provision when an owner, when a transferring attorney provides information of a potential sale or a sale that's progressed. We make provision by asking for levies 3-4 months, even past the expected transfer date, and that's why there's generally a rebate or repayment back to the owner once transfer has taken place. And I think it's a very important thing, because the alternative is that transfer takes place and there's an arrears, and then you need to try and fight with the owner that's already sold, and you generally don't get that owner to pay up. So that can be a very big problem for body corporate.
What you can do there, Leigh, is if a transferring attorney transfers without a levy clearance certificate, then you sue the transferring attorney, and they have indemnity cover in place.
Right.
So as opposed to going back against
has that happened quite a bit?
Yes, yeah. Quite a few times we've seen transferring attorneys issue levy clearance on their own and transfer a unit, and we as managing agents none the wiser. Carry on with legal, carry on with whatever, and we don't even know that there's been a transfer of ownership. Then we would sue the conveyancing attorney. And we get it paid very quickly.
Okay. All right. Well, it's good to know. Touch wood, we haven't had to do that, but thanks for that advice.
Pleasure.
Nicola, Jeanette, thank you very, very much for your time. Obviously, always insightful to hear from the experts how they deal with these kind of things, and we certainly learned a lot from that. So thank you very, very much for that. I'm going to ask Zerlinda, are you there? Say hi or bye.
I think you have to unmute her.
Yeah, she is there.
Again.
She's been in the chat.
Okay.
I think you just have to unmute her.
Okay. Let me get there quickly. There we go. There's Linda. There we go. How are you, Zerlinda? Are you there?
Hello?
Hello, how are you?
That's one way to make sure I don't give my 2 cents. Just mute me. I had so many things to say when you started talking about the seesaws.
Yes. Thank you so much for joining us, Zerlinda. So Zerlinda, obviously from TVDM, specialist, let's call it specialist sectional title attorneys that deal with literally every possible thing that you can imagine that a managing agent is not able to deal with, or where the trustees want more legal advice. Thank you so much for your time and joining us. I've specifically earmarked Zerlinda to talk about this side of the session this evening is about maintenance versus improvements on common property. What I'd like to get to very quickly is improvements on common property. So just the main thing, maintenance common property, it's generally budgeted for in the administrative budget. So that would be your annual budget, where you make provision for monthly, quarterly, biannual expenses, all for bigger projects, but not of a capital nature, but that would be in your maintenance reserve and replacement plan, your MRP. We all know about the requirement to have a maintenance repair and replacement plan for capital expenditure. And this is my bugbear. I always complain about the consultants that we use, although we like them and they do a good job. Some guys always tend to put in, annual maintenance figures in there, and I always go back to them and say, please take this out because it's already budgeted for in the administrative budget. You can't budget for it twice. But anyway, the point here is your bigger projects of a capital nature, you put in your maintenance reserve and replacement plan. So what are your common property items or things that you need to maintain? Obviously, the list is very long: roofs, walls, parking areas, walkways, lifts, staircases, passageways. I mean, there's a whole host of them, and a lot of them you could probably, if you've got it, every scheme is different. There might be different things in a scheme that you need to maintain from a body corporate perspective. So there's a whole host of things that needs maintenance, and obviously the trustees need to consider all these things that they need to put into the administrative budgets, which they need to plan for every year. And from a maintenance reserve and replacement plan or MRP perspective, we're talking about long-term things. Are we going to replace the lifts in 8 years' time? It's going to cost us 600,000 Rand today, but in 6 years' time, it's going to cost us R1 million. So we need to budget for that. You need to have your cash flow ready. You need to be able to work out how much money you have and how much money you're going to need in order to actually be able to pay for those things. And again, I don't want to go into too much detail, but one of the big reasons for the maintenance, repair, and replacement plan is so that a body corporate doesn't find itself having to raise special levies, because special levies put people in financial distress. You can't suddenly, if you don't have it, get 50,000 Rand unless you go and borrow the money or, you know, take out a loan against your property or something like that. I wanted to ask Zerlinda, this is where I made a mental note, damage caused by an owner or a tenant to common property. I mean, I know what the answer is, but from your perspective, how does the body corporate deal with this, and how does the body corporate recover the costs incurred in that?
So, you know, when it comes to the recovery of costs, and Nicola touched on it when it came to legal fees and penalties and administrative charges and all of those fun things, you know, we have to make sure that it's in the rules or in the Act. And the Sectional Title Schemes Management Act, the prescribed management and prescribed conduct rules don't actually deal with damages to common property, which then means that you have to have amended management or conduct rules allowing the body corporate to recover any damages from an owner, either through their own cause, alternatively through a visitor or a tenant or something along those lines. And things that happen often, Leigh, I'm sure that your guys have dealt with it quite frequently, is the tenant or the contractor or the visitor driving into the entrance gate or the exit gate. I know that we very often used to get those. And then the body corporate has to make an insurance claim, and who does the insurance go after, and all those fun things. So if you don't have it in the rules, you can't automatically recover the damages. We used to talk about fighting with CSOS. We used to have the proposed rules declined by the CSOS when we attempted to have a damages recovery rule. First, they said, no, it can't be in the conduct rules. It must be in the management rules. Then they said, okay, fine, it can be in the conduct rules. Then they said, no, it's a delictual action. You can't enforce that in the conduct rules. For the last few years, they have been accepting it in the conduct rules, at least from what we have seen. So that's one of the first amendments to conduct rules that we put into place to allow the body corporate to automatically recover any damages that is caused to the common property, either by an owner or their tenant or visitor or contractor or staff member, etc., etc. If you don't have that rule, obviously you can take the chance and recover it. However, if it does go to the CSOS, if it does have to go to internal dispute resolution, unless it's in the rules, it is going to be difficult to enforce. Otherwise, you'll have a delictual action, which is something that you can attend to through the small claims court, magistrates court, or high court, depending on the amount.
Yeah, but I mean, the same would apply like on the legal side, or legal costs, for instance. If the owners agree to it, then you can charge them, right?
Yeah, 100%.
Yeah. So that's always going to be your first attempt, is to say, listen, you know, we've got it on camera. You drove into the gates. This is the quotes. You can get another quote or whatever, but you know, you agree to paying this, and even come to an agreement of potentially paying it off over 2 or 3 months or whatever the amount is necessary. So as long as the owner agrees that they're happy to pay for that cost, then you can proceed on that. But other than that, you're basically venturing back to changing your rules, right?
Exactly. We must also be careful about entering into any agreement. And I know if Mike Addison was online, he would say, be careful about making arrangements outside of your insurance broker or your insurer, because if you enter into any of these agreements, you in actual fact repudiate any potential opportunity that you have to make an insurance claim. So the first port of call would be to contact your insurance broker. And then to deal with the excess and things like that, you'd go against the owner.
I agree. No, 100%. Yeah, and I think that's an interesting point. And you know, we should probably have an insurance session soon and get Mike on here as well. Then again, I know we can talk about this for a long time. You and I have had a discussion about this, and I've come around to understanding what you were saying. Exclusive use areas, it's common property, the body corporate versus the member having the right to the EUA. Who's responsible for the maintenance? In short,
Okay, so unless, again, there's a rule that says something different, and it can be a management rule or a conduct rule according to CSOS, I lean more towards management rules, is that the body corporate is responsible to do the work, but the owner or the holder of the exclusive use area is financially responsible always. There should be a contribution that's recovered from the body corporate to pay for this maintenance or remedial or replacement work, and often when there isn't or isn't a sufficient amount, it can be recovered directly from the owner.
Yeah, and I think, again, I've touched on this in previous sessions where exclusive use levies or exclusive use area levies are collected. And then you have the scenario, for 10 years, 15 years, no expense has been incurred on that exclusive use area, but the owner's paid a levy, and then suddenly you need to incur costs of 50,000 Rand, but you've only collected 40,000 Rand. And then you've got to go back to the owner and say, so you're responsible for the difference. You're responsible for the other 10,000 Rand. And I think somewhere it's going to blow up, because I just don't think that the industry at all, in general, has really made provision for that sufficiently.
No, you're 100% correct. And what's even worse than that is where the exclusive use area contribution that has been recovered hasn't been allocated to a specific exclusive use area, or even exclusive use areas generally. It's just been absorbed or swallowed up by the rest of the administrative or the reserve fund. And very often, trustees look at me, like, what are you talking about? When I say that there actually has to be a line item both in your admin fund and your reserve fund for exclusive use areas, and they need to be treated separately. You can't go and take that income as a globular amount into your entire budget amount. So very, very important to separate it.
Yeah, I think that it comes down to how the budget is done, and I'm a strong believer that needs to be taken out of the budget and kept separately. I mean, it's almost like a third budget that you should have, because you also need to consider, is the other contributions actually sufficient for the potential maintenance that you need to incur? I mean, it's a bit of a minefield, but like I said, I certainly believe there's a right way of doing this, and I don't think the industry is doing it correct.
I think your idea of having the third budget is a good one. You can do it for the reserve fund, so why not for the exclusive use areas?
No, correct. I'd like to move on to the maintenance sections or UAs when the owner does not attend to it. Legislation says that the body corporate can proceed to do it. Obviously, there needs to be communication. But I mean, in your experience, how has that gone down? Has it been done successfully? Because I think the problem is, like, when you have the balconies and terraces is a good example, where the balcony or the terrace is either exclusive use area or it's actually part of the section, and it's leaking into the unit below, and the owner is informed about it, but they don't do anything about it. But the body corporate can't just storm into the apartment one day and arrive there with the maintenance team, and guys start lifting up tiles and all that kind of stuff. So, I mean, how do you really deal with this other than potentially going to court or going to CSOS?
So under the old act, it was a lot simpler, because you could literally barge in as the trustees. I always like to think about that practically, because owners do not allow access into their sections or exclusive use areas, even when they know that work has to be done. But under the STA, the trustees could send somebody in to undertake any remedial work to a section if it affected both a common property or another section, or both. Now, under the SDSMA, you have to ensure that it is causing a general problem, like a problem generally to multiple sections, to the building as a whole, to the owners and the residents, that it has to be something that's going to affect the structural integrity, like something really, really serious or adverse. You can't just simply send it in because somebody's got a leak somewhere. The access issue is a problem, because although the act says an owner must allow access, very often that is not the case. I've had instances where a body corporate has sent a contractor in through the common property to access an exclusive use area balcony or a part of a section balcony, and the owner has physically stopped the contractors from entering, pushing over ladders, all sorts of fun things. So it is difficult, and you'd essentially have to go to the CSOS. But very often these things are urgent, as in they require urgent remedial work. And
so you can't wait weeks on end to get to a meeting where you're not going to agree either.
No.
Okay. So effectively, I mean, if nice talking or asking or requesting is not going to work, you unfortunately you're gonna have to revert to either the court or the CSOS.
Yeah, CSOS,
Okay.
or if there's a ground for urgency, and the members and trustees have to be very, very careful about going to court as opposed to the CSOS, because in
Yeah.
all likelihood the matter will be referred back to the CSOS with costs, but there are grounds to go to court in these types of urgent matters. Of course, it's going to be very expensive.
It's an interesting point you make there, because I think you've also done this many a time. I've read a adjudication order, well, let's call it an adjudication opinion of 14 pages, and at the last sentence is CSOS says, well, we don't have adjudication over this jurisdiction, over this matter.
Yeah,
I just spent like 30 minutes reading a 14-page document, which absolutely meant nothing. Yeah.
Yes, 100%. So dangerous, eh?
Yeah. All right, so the more interesting one, the reasonably necessary versus the not reasonably necessary improvements to the common property. So before it was luxurious and non-luxurious improvements. I mean, obviously everybody can see and read what is on there, but Zerlinda, from your side, I'm going to leave it to you. The difference between these and the practicalities and the impracticalities of that, and maybe like one of the things that I've recently had to deal with is signage, like a signage billboard that owners want to put up at a building, and there's quite a dispute about, is it the trustees' approval, is it PMR 29 or whatever the situation is. I'm going to leave it to you to run through that.
Perfect. So the thing to remember about PMR 29, 1 and 2, the alterations or improvements to common properties, that it's a trustee improvement alteration, a trustee motivated and trustee project. It's not an owner wanting to do something to the common property. That would need to be dealt with either as an exclusive use area extension of a section, trustee resolution, all those fun things. So when the body corporate is wanting to do something, either they're wanting to install something or erect something or change something, alternatively they want to take something away, then the trustees have to sit down and consider whether or not what they propose to do is reasonable in the context of that specific scheme or not reasonable. And what I say to trustees is, the moment you feel uncomfortable about your decision, you should definitely rather go the member route. So in other words, immediately go to a special general meeting, immediately propose a special resolution, as opposed to waiting this 30 days for somebody, only one person, to ask for a meeting. When it comes to not reasonably necessary improvements, the list is a lot shorter. I normally say that it's something that you want as opposed to something that you need. So we would like it, we don't have to have it, it doesn't really bring us benefits, but it's something that we would like in the long run, and perhaps we could spend our money better elsewhere, and we don't have the money for it right now. That is something that lends itself more towards not reasonably necessary. If we look at Cape Town, when we were going through water crisis, then JoJo tanks were a necessary improvement. When we went through load shedding, touch wood, then the solar and the alternative energy is a necessary improvement. When we look at security, then security is a necessary improvement. So it really does depend scheme to scheme. I will never forget that I dealt with a body corporate where they had a common property swimming pool and they wanted to install another 2. So they wanted 3 swimming pools in this building. And I thought to myself, wow, that's most certainly luxurious. And then they said, no, when potential purchasers come in, they actually do not purchase the units in this building because a few of the schemes around have more common property facilities. And this scheme actually needs to have the additional common property facilities to ensure that the market value of the properties are reached. So in their case, that was considered to be reasonably necessary. But, in a different scheme, that might not necessarily be the case. So it is really scheme to scheme. And then, like I said, the biggest thing that comes up very often with us is that when an owner is wanting to do something to common property, the trustees or the managing agents automatically go towards this clause, and it doesn't apply for those types of projects.
Okay. Yeah, I mean, I think that the interesting part there, or the thing to remember is 2 things. One is that, if the trustees feel uncomfortable about what is being proposed, then rather go to a special general meeting, because then you're getting a lot more owners involved in making that decision, or objecting to it. And I think on, the example that I used for the signage is interesting enough. In 2014, 10 years ago, they attempted exactly the same thing that's come up 10 years later. And in 2014, it was rejected by the owners. Now, 10 years later, we have exactly the same scenario, and it's seemingly the same fights are starting and the same arguments and everything like that. So
as
that's
change.
yeah. So I think that's the interesting thing, and that every scheme is different. You know, it's almost the same example where owners ask, well, you know, what are levies going per a rate per square meter in a building of a similar size? I'm like, well, you know, how long is a piece of string? Because every building is different. And I think the point I'm trying to make here is that when you get confronted or you know have to deal with a situation like this, you need to apply your mind to the scheme and not about, you know, the guy living on the ground floor that thinks it's not necessary, reasonably necessary, or the guy on the top floor that thinks it is. You've got to apply it to the scheme and apply your minds and your thoughts on how to deal with that.
Yeah, very much so. The importance of getting the members involved, you know, is emphasized by the fact that during this 30-day notice period for reasonably necessary improvements, any one owner can request a special general meeting. I mean, nowhere else in the Act can one owner have that much of an impact on a building. So very important to take that into consideration. Yeah,
and you can see that an owner may request a general meeting, and then you've got to go to a special general meeting. All right, we finished for the hour. I want to just quickly see if there's anything in the chat. I know we've gone through an hour. Obviously, I haven't spent any time reading of any of these. Some of them might not be relevant anymore. We can't unmute ourselves. Yeah, that's about penalties for late. I think that was answered. Okay, there's a quick question here, Paul. Is there any review of a CSOS award, and if so, what is the competent court? Maybe don't know if Nicola is still here.
Yeah, no. It would be you can review it to the High Court.
High Court. Paul, okay, the High Court. There's Zerlinda. You answered. Yeah, great. How do you deal with an owner of multiple units? The owner, therefore, has a majority of the people in trust, and he's an outright bully. Okay. I'm not sure we're going to get through that tonight. Aaron, the STA require that trustees raise levies on EUAs from the owner who enjoy that EUA to cover possible maintenance. If no maintenance is carried out by the BC during a particular financial year, can that levy be carried over to the following year? Zerlinda, Nicola, I mean, that it does get carried over. It effectively starts.
Yeah, I think Zerlinda already answered that one. She said should add up.
And also it carries over from owner to owner because the EUA still remains with the section. There we go. Nadia, when an owner has improved the wooden windows and doors, the body corp agrees that they cover a certain amount. They pay the owner. That's the line is reached. Common practice. They pay the owner or agree that the levy be waived. Okay.
Don't make that
waiving of levies is not a good thing at all. That shouldn't happen.
The simple answer is there that the owner should not be replacing the window frame that is on common property themselves. And if they are going to do that, then, you know, the body corporate has no obligation to refund them, and there shouldn't be a waiver, most certainly not.
I think
they can agree that they'd pay for it, and then the portion would be credited back to them, but not waive.
No, not waive. Yeah. And then this one, obligation by an owner to pay the levies if they argue that they didn't get the invoices.
No, that's not a requirement for paying your levies. As members, you buy into the body corporate, you're liable for all the assets and liabilities of the scheme, and it's on you as an owner to make sure that you attend the AGM and that you're part of the budget and that you receive everything. And if you haven't received it, you must follow up with your managing agent. You know that you have an obligation to pay your levies by the 1st of the month, and there is absolutely nothing in law that says that you must receive a statement to pay levies.
Correct. In fact, I think the legislation actually says that there's no obligation to say. It's almost the same as a meeting or general meeting or AGM it's not voided because people didn't receive the notification of the meeting.
Correct. Yeah,
correct.
It's on you to make sure that you've got it.
Perfect.
And as Janae just said, ignorance is not an excuse.
Right, guys, we've exceeded the 60 minutes. We always try and keep to the 60 minutes. Obviously, we're very aware of your time that you've taken to join us this evening. Thank you to Zerlinda from TVDM and Nicola from ZDFin for joining us.
Thank you for having us.
thank you so much for your input. And for those people that joined us, thank you for your time. We will send out the recording, so you'll be more welcome to listen it again on your own time. And we hope to see you next month at our next training session. Thanks so much. Have a good evening, guys.
Okay, thanks so
everybody.
much.
you.
Thank
Thank
you.
you.
Bye.
Bye-bye.